truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Good morning, everybody. Good morning. Good morning. Good morning. Hi, folks. How are you guys doing? Let me put some sound effects. I think I'm going to start doing sound effects now. Ready? I'm going to say good morning. Good morning. All right, guys. Let's get started. I am going to start with first, let me say hi to folks in the chat. Hold on a second. Let me say hello to my people that's in the chat. Good morning, Serena. Good morning, Nosy Rosie. Good morning, Miss Ronnie. Good morning. Let's see. Good morning, Margie C. Good morning, Coco. Good morning, Miss Torres. Good morning, Keith. Good morning, Miss Richard. Good morning, Pretty Chick. Good morning, everybody that's in the chat. I want to say hello to you guys. Anybody else that comes in, hello, and do a blanket hello to everyone. Hope you, hey, Jackie, you slid on in here. Yep, she slid on in here. But this morning, we're going to discuss Tiffany Haddish, the trial that is supposed to start on August the 10th. But before trial starts, she is having a hearing with Judge Thompson. Judge Thompson is the judge on the case. Now, we will discuss. This case happened back in 2022. Can you believe that? 2022. And they're just getting it. And look, let me tell you something. The other thing, too. Every single one of the counts are misdemeanors. Misdemeanors, y'all. Misdemeanors. These are not real, like, felonies. These are misdemeanors. Yes, misdemeanors. But I guess the judge wants to make an example out of Miss Haddish. We talked about how money makes things go well, but sometimes money makes things make you an object to scrutiny, and you are going to be set as an example. An example. Right, y'all? All right. Okay. Thank you very much. Thank you very much. But anyway, Tiffany was arrested back in January 14th of 2022. In the charges that she received during that arrest, well, she got a couple of citations, but the charges she got was DUI. We know that. That was the first charge. Second charge, she has a second charge, DUI drug. Then the number third charge was driving under influence of multiple substance. Georgia 440-6-391 A4 and A2. Then another one, DUI per se, number 4, 40-6-3391 A5. Then she received an improper stopping on a roadway. That was the 6th charge. The 7th charge is vehicle to be parked, power of department transportation. So I think, I'm not too sure. I think it was something having to do with running into a parking area. I mean, the yard of somebody. And they got the multiple utility underground. So I'm wondering if that has to do with the power that they're talking about. I don't know. I really don't know. But that's what she is charged with. So let's go over it again. On January 14th, 2022, Tiffany Haddish was arrested as well as charged. She received a citation in regarding to the following charges: 1, DUI alcohol; 2, DUI drugs; 3, driving under the influence of multiple substance; 4, DUI per se; 5, obedience to traffic control device. Oh, I didn't say that one. Number 6, improper stopping on the roadway; and number 7, vehicle to be parked, power of Department of Transportation. So those are the charges, and every single one of those charges are a misdemeanor, and they were all done on January 14th, 2022. Upon her arrest, she was allowed to make bail the same evening or next day morning, but she was detained for a few hours. I think they did have the thank you. Yes, please guys, smash the like button if you would, please. I think I do have the arrest. Hold on a second. I'm trying to pull up the arrest. Hold on a second. Okay, hold on. And remember, she had just gotten arrested in hold on. All right, let's go ahead on and show you this. She did get arrested in California a couple of months prior to this one. This was like our second one. Here we go.
Haddish arrested early this morning, suspected of DUI. The Fayette County, Georgia Sheriff's Office released this mugshot of Haddish. Our ABC affiliate in Atlanta, WSB-TV, reports Peachtree City Police were responding to a 911 call about a driver falling asleep at the wheel along Highway 74 around 2:30 this morning. An officer performed a traffic stop and Haddish pulled into the yard of a nearby home. Haddish reportedly posted bond a few hours later. A source close to Haddish did tell Eyewitness News that it's been a tough couple of weeks for the star, including the death of her grandmother. Hello, I'm Mark Brown.
Hold on a second. They got some more on that particular arrest. Hold on a second. Hold on a second. Hold on a second. Let's go ahead on that and do another news reporting. Oh, I forgot to make my announcement. Hold on. Let me make my banner announcement. A copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for the purpose of criticism, comment, news reporting, teaching, scholarship, and research. We're doing news reporting right now because we're giving an update on her upcoming hearing. All right, here we go.
Tiffany Haddish was arrested last night, Friday, January 14th, and charged with a DUI. The actor and comedian was detained in Georgia after Peachtree City Police got a call about 2:30 a.m. regarding a driver asleep at the wheel on a highway. Officers had a description of the vehicle and were on the lookout for it when they spotted Tiffany pulling into a neighborhood. They arrested her for DUI and improper stopping on a roadway. Cops believe she'd smoked marijuana. Tiffany was only in police custody for a few hours. According to records, she posted a $1,666 bond and got out of jail around 6:30 a.m. A spokesman for Haddish did not immediately respond to an emailed request for comment. Haddish was the breakout star of smash comedy Girls Trip and has starred in such movies as The Kitchen, Night School, and Like a Boss. She's also written the New York Times bestseller The Last Black Unicorn and hosted the popular television show Kids Say the Darndest Things. In 2020, Haddish won the Best Comedy Album Grammy for Black Mitzvah. All right, for more on this developing story, head to thr.com. For the Hollywood.
Okay. All right, that was the reporting of that. So hold on a second, y'all. Let's see if we can get some more news on. Hold on a second. We're trying to pull it up. Just bear with me a second. Trying to see if there's another one that we can look at. Hold on. All right, let's do radar. Radar has something on here too. Hold on. I think they have the 911 call. Hold on. Just 1 second. Let me share this with you guys. Now we have to go and get other sources. All right, here we go.
The Georgia prosecutors who charged Tiffany Haddish for allegedly driving under the influence in 2022 are demanding a 911 call be entered into evidence in the case. According to court documents obtained by RadarOnline.com, prosecutors asked the court to allow them to play the 911 recording of a concerned citizen to the jury at the upcoming trial. On January 14, 2022, a concerned citizen called 911 and reported that a motorist was asleep at the wheel at a traffic light. The caller observed the driver appeared to be asleep in the driver's seat with their foot on the brakes, the prosecutor said. This vehicle turned out to be the vehicle defendant was operating. The caller was giving information to the communications center while the police were being contacted. The prosecutors argued the call was admissible and it being played did not violate Haddish's Sixth Amendment rights to confront witnesses. As we previously reported, Haddish was arrested in January 2022. The Peachtree City Police Department received a call about a driver who had fallen asleep at the wheel. Officers pulled over Haddish's car. They claimed her vehicle matched the description of the car the caller reported. According to police reports, officers said they smelled marijuana from Haddish's car. The comedian was arrested for misdemeanor DUI, driving under the influence of multiple substances, and improper stopping on the roadway. Haddish's lawyer argued the charges should be dismissed. He said the officers did not have reasonable articulable suspicion to detain Ms. Haddish. The comedian's attorney said Haddish's car did not match the car the concerned citizen called in to report. He said the car police were looking for was a white Chevrolet SUV with a possible Florida tag. He said Haddish was driving a white Ford Explorer. He said the officers saw Haddish's car and followed her for 1 minute before pulling her over. He said the entertainer did not report observing Haddish violate any traffic laws. As a result, he argued the traffic stop was illegal and any evidence derived therefrom must be suppressed. He said the officers followed Haddish for 1 minute before pulling her over. Haddish's lawyer demanded all fruits of the unlawful seizure of Haddish's person, Haddish's blood test, and any statements Haddish is alleged to have made on the grounds that they were the fruit of the unlawful search and seizure. As RadarOnline.com first reported, in the case, Haddish was ordered to submit to random drug tests and not drink alcohol in the case after being arrested for a second DUI in LA in November 2023. In the Los Angeles case, officers found Haddish behind the wheel of a car in the middle of the street in Beverly Hills. The charges were eventually reduced to a wet reckless and she avoided any jail time.
All right. So that is that. And then the recent updated, let's go ahead on and do the recent updated on a couple of weeks ago. Hold on a second. Let me bring that up for you guys. Okay, this is a couple of days ago here.
Says her DUI case has dragged on so long it should be thrown out. But prosecutors are fighting back, arguing that the actress hasn't shown the delay actually hurt her. According to new court documents obtained by TMZ, the state of Georgia is urging a judge to reject Haddish's motion to dismiss the case, which stems from her January 2022 DUI arrest in Peachtree City. Prosecutors acknowledge the more than 4-year delay weighs against them, but they insist it wasn't intentional and shouldn't carry much weight. They also argue Haddish announced Haddish announced she was ready for trial, but never actually requested an immediate trial, a distinction they say matters under Georgia law. The filing takes direct aim at Haddish's claim that the unresolved case has damaged her career and limited her ability to travel internationally. Prosecutors say she's offered no evidence beyond broad assertions that she's lost work as an entertainer or been unable to visit certain countries because of the pending charges. The state also argues Haddish hasn't really suffered from the delay, noting she has not been incarcerated while the case has been pending. As for her claims of anxiety and stress, prosecutors say those concerns are common in criminal cases and aren't enough on their own to justify a dismissal. As Tiffany Haddish says her DUI case has dragged on so long it should be thrown out, but prosecutors are fighting back.
Okay, so that is what they're saying. So now, what is happening now? I went into the Peach court, and I went to try to pull some of the information on what happened. Well, the judge did rule on some of the things that her attorney was trying to suppress. There has been an order for suppression of certain things. And one of those things was the her not getting her Miranda rights read to her. The state introduced, okay, maybe I should order this. Let me buy this so I can read this to you guys. $7 for this mess. They always trying to charge you for something, y'all. Let's go ahead on and buy this so we can see what. Hold on. $7.55. These people, man. Rip off. Highway robbery. All right, we're going to buy this. We're going to purchase this, okay? Just bear with me for a second. I'm going to put my stuff in here. What's my name on this thing? All right, card number. We're gonna do a MasterCard. All right, so we're gonna save that, and we're gonna pay Place an order. Place an order. Okay, we just placed the order so I could pay for that daggone thing. Okay, we're going to download it. All right, I just bought it. Let's see. All right, here we go. All right, so I just purchased it. Let's go ahead on and bring it up here. I tell you, everybody was trying to tax us for dollars. All right, here's what the court says. The officer lacked PC. Any evidence gathered past the point of violation of the Fourth Amendment cannot be used against her. Okay, here's the judge's order. Let me put my what's the name up on here. Hold on a second. Let me put my hold on. Let me put my you know what I mean. Oh, what's the name up here? Oh, not that. We gotta put my watermark. Hold on. All right, there we go. We're gonna put my watermark on here so we can go ahead on and look at the paperwork. All right, here we go. There we go. All right, here we go. Can y'all see it? All right. Georgia versus Tiffany Haddish. Right, you guys know I just purchased this thing here. If you guys want to offset some of its costs, y'all please help a sister out. Hold on a second. All right. It says, order. The above style case comes before the court on the defendant's amended motion to suppress. The court heard oral argument, right? The court heard oral argument. And on this motion, and thank you, the 7 for you. The 7 for you. Thank you, Williamson. The 7 was for them. $7.55 is for them. They took them. It was $7.55 for them. I don't know where that 55 cents come from, but thank you so much, Williamson. You're the bomb. Thank you so much for being a blessing. All right, let me finish reading this. Okay, it says here that the court heard oral arguments on this motion and listened to or view State's Exhibit 1 911 call recording. State's Exhibit 2 Sergeant Isaac dash camera video. State Exhibit 3 copy of the implied consent card. And State Exhibit number 4 Sergeant Phillips body cam video, right? Says here, factual background. The state introduced into evidence the recording of a 911 call on January 14, 2022 at or around 2:30 a.m. State's Exhibit 1, the 911 caller reported that the driver of the white SUV with Florida tag at the intersection of Highway 54 and Highway 74 was asleep at the wheel, despite other drivers blowing horn at the vehicle. Sergeant Phillips of the Peachtree City Police Department provided testimony regarding the traffic stop, investigation, and subsequent arrest of the defendant. In addition to the 911 call, a driver stopped at Sergeant Phillips' police vehicle to report the white SUV stopped at the intersection of Highway 54 and Highway 74. As a result of the 911 call, the driver's report to Sergeant Phillips radioed a dispatch regarding the white SUV with Florida tag and the bolo. After airing the bolo, Sergeant Phillips learned that from another officer, Officer Kirby, that the white SUV matches the bolo was driving slowly on Willow Road. Pursuant to testimony provided by Sergeant Phillips, Sergeant Kirby completed a U-turn in his marked patrol car and followed the vehicle to 11 Pell Stump Point. You know what? You know what, y'all? I think I need to sorry, y'all. I think some things I need to take down. Sorry. I should have redacted some stuff. Oh well. Let me just read and then bypass certain things. And let me stop sharing this. I think that's what I'm gonna have to do because I see I'm revealing addresses. Ooh, that's a no-no. Sorry, y'all. Sorry. I'll just read and bypass certain things. So my bad. All right. Sergeant Phillip arrived at the location shortly afterward. At that time, the defendant was in her driveway next to a white SUV with Florida tag. Sergeant Phillips informed the defendant of the bolo regarding the white SUV with Florida tag. The defendant did not deny her involvement in this event, but instead responded that she was tired. Sergeant Phillips also testified that the defendant admitted that she was stopped at the Highway 54 and Highway 74 intersection when someone knocked on her window. Sergeant Phillips testified that he is post-certified and had successfully completed standard field sobriety and advanced roadside impairment driving enforcement training prior to the arrest of the defendant. As part of this training, Sergeant Phillips became certified to administer horizontal gaze and naconyms. That's a testing. After conversating with the defendant briefly, Sergeant Phillips asked if he could check the defendant's eyes. The defendant consented and he began the HGN evaluation. Sergeant Phillips continued the field of sobriety evaluation by also conducting the walk and turn and one leg stand evaluation. Sergeant Phillips testified that he observed the following with respect to the defendant's field sobriety testing. Now, this is what his outcome is. You said most people don't know how to access it. Oh, okay. But I mean, so most of the time I redact the addresses, but I guess you're right. Let me go ahead on and show this for this part anyway. Let me see hold on a second. Let me see if I have something that's like going to show addresses and stuff like that coming up. I don't see any addresses coming up. No, I don't see anything else. But you know what? You're right. Bump it. I didn't put anybody's name and stuff like that because we don't have names on here. Yeah. Okay. All right. We're gonna go back. Okay. Let's see. Yeah, and this is an order. So this order is public record. All right. This is an order. This is not a citation. This is an order. This is public record. You're absolutely right, Williamson. You're absolutely right. You're absolutely right. Let me go ahead on and show it again. Hold on, y'all. Just bear with me. Let me put it back up. You are absolutely right. This is a court order. All right, here we go. I gotta go back up. Where was I at? Someone knocked on her window. Let's go up. Okay. All right. This is the testing of sobriety testing that they did. They did 4 of 6 clues during the HGN evaluation. During the walk and turn, the defendant started the test too soon, used her arms for balance, had the incorrect number of steps, and missed heel to toe, and 2 of the 4 clues during the one-leg stand evaluation. Sergeant Phillip testified that while completing the field sobriety test, he observed the odor of marijuana coming from the defendant's jacket and the smell of alcohol coming from the defendant's breath. Based on his observation regarding the smell of marijuana and alcohol, the BOLO regarding a white SUV with Florida tag, and the result of the field sobriety evaluation, Sergeant Phillip testified that he came to the opinion that the defendant was impaired to the extent that she was a less safe driver. Sergeant Phillip subsequently read the Georgia implied consent card to the defendant for the breath test multiple time. The defendant did not affirm or deny her consent for the breath test to Sergeant Phillip. As a result, Sergeant Phillip read the Georgia impaired consent card to the defendant for the blood test. The defendant agreed to provide a blood sample. During the reading of Georgia implied consent card, the defendant says, "So I could get a nurse of my choice?" Sergeant Phillips placed the defendant under arrest and escorted her back to the back of his patrol vehicle. He then transported her to Peachtree Police Department for blood testing. Sergeant Phillip testified that he did not read the defendant's her Miranda right at this time. Well, he messed up, y'all. He didn't read her Miranda rights. So that's going to be thrown out, y'all. It's going to be thrown out because he didn't read her Miranda rights. At least he admit the truth. He didn't read it to her. All right, here we go. While in the patrol car, the defendant asked multiple times if she could blow now. Sergeant Phillips replied by telling her that she would be able to do that at the jail if she would like. Sergeant Phillips testified upon redirect that Miss Haddish did not ask for any breath tests while at the jail. Sergeant Phillips also testified that after the arrest, he informed the defendant that she smelled like marijuana, and the defendant admitted that she smoked weed. Wow. B, analysis. Counsel for the defendant raised the following challenge to the court's consideration. Number 1, whether the officer had articulated articulable suspicion to make the traffic stop. 2, whether the field sobriety evaluation were conducted correctly. 3, whether Sergeant Phillip had probable cause to arrest the defendant. 4, whether the state had the requisite consent from the defendant to perform the SFSTs. 5, whether the defendant was denied the opportunity to obtain an independent test following her arrest. And number 6, whether the defendant post-arrest statement were admissible because she had not been read her Miranda rights. Each of these issues is discussed below. Articulable suspicion. In order to engage a vehicle in a traffic stop, an officer must have specific articulable, I can't say the word, me and these words, man. Facts sufficient to give rise to the reasonable suspicion of criminal conduct. Thomas versus State 261, and there's a case law on that. Articulable suspicion may rest upon the collective knowledge of the police when there is some degree of communication between them rather than solely on the information posed by the officer who actually makes the arrest. Blanks versus State. Also, Goodman versus State. Then you have State versus Maddox. Recognizing that the police officer are authorized to use information received by radio dispatch as part of their basis or for articulable suspicion to conduct a stop. Thus, the question regarding whether Officer Kirby had articulable suspicion to perform the stop should be resolved based on all the information known to both Officer Kirby and Sergeant Phillips. See Blanks versus State. In this case, the 911 caller specified the color, the type of the vehicle, and the Florida tag, as well as the intersection where the driver was stopped. An individual also stopped Sergeant Phillips' police vehicle to make this report with the same details directed to Sergeant Phillips. Based upon this information, Sergeant Phillips subsequently issued the bolo. Sergeant Phillips testified that Officer Kirby heard the bolo and then noticed a vehicle matching the same description driving slowly in a location not far from the intersection of Highway 54 and Highway 74. These events took place in the early morning hours when there was very little traffic. Given this specific information, known to both Sergeant Phillips and Officer Kirby, the court finds that Officer Kirby acted on articulable facts sufficient to give rise to a reasonable suspicion of criminal conduct. So that one, they lost that part. Next one, field sobriety test. The defendant's challenges when the HGN evaluation and the field sobriety evaluation was conducted correctly in this matter. Under Georgia law, the trial court is charged with considering the officer's qualification to testify as the HGN test, as well as the relevance and reliability of the proffered testimony based on the Darbert standard, State versus Chambers. That's a case law there. On February 7th, 2025, the court issued an order which took judicial notice that the HGN evaluation meets each of the factors underlined by OCGA 24-7-702 B1, 2, and 3. See State of Georgia versus Whitmore on Fayette State Court. Having determined that the HGN evaluation is admissible evidence under OCGA 24-7-702 and Darbert, the court turns to whether the principle of the HGN evaluation were reliable applied in this matter. When the defendant informed Sergeant Phillip that she had a lazy eye, Sergeant Phillip continued the HGN evaluation without further questioning whether the impact of the lazy eye on the defendant's Additionally, Sergeant Phillips testified that he stopped at a certain point while administering the HGN passes to the defendant. Thus, it does not appear that the passes were performed smoothly, steadily, in continuous manner, as required by Sergeant Phillips' training. Finally, Sergeant Phillips testified that he did not ask the defendant to keep her head still during the evaluation, as required by HGN evaluation training. Given these irregularities, this court agrees that the application of the HGN evaluation was not reliable. reliably applied in this manner. The court finds that the results of the HGN evaluation shall be suppressed. So they're going to suppress the evaluation of the sobriety testing and the HGN. So that's going to be thrown out. That's suppressed. Okay. Based upon a review of Sergeant Phillips' body camera video, the court finds that Sergeant Phillips substantially complied with his training related to his administration of the walk and turn and one leg standard evaluation. The result of the walk and turn and one leg evaluation will be admitted. So that part will be admitted, but the other part will not be admitted. The HGN part was not be admitted. All right, probable cause. Now let's go into the probable cause part. It says here, the defendant also challenges whether Sergeant Phillips had probable cause to arrest her. In Georgia, probable cause to arrest an individual for a DUI less safe exists where the facts and circumstances known to officer would support a reasonable belief that the suspect was actually in a physical control of a moving vehicle while under the influence of alcohol, to the degree which rendered her incapable of driving safely. State versus Color. All right. Sergeant Phillips testified to the following facts. 1. He issued a bolo regarding a white SUV with Florida tag with a driver asleep at the wheel not far from the location of the traffic stop. 2. Within a few minutes of the dispatch, Officer Kirby spotted a white SUV with Florida tag driving slowly. 3. The defendant admitted that she was stopped at the Highway 54 and Highway 74 intersection when someone knocked on her window. 4. During the walk and turn test, the defendant started the test too soon, using her arms for balance, used the incorrect number of steps, and missed the heel to toe instruction. And 5, the defendant demonstrated 2 of 4 clues in the one leg stand evaluation. Sergeant Phillips also testified that while completing the field sobriety tests, he observed the odor of marijuana and the smell of alcohol coming from the defendant's breath. In undertaking a probable cause analysis, the court must consider the facts and circumstances altogether, for it is the totality of those facts and circumstances that matters. Not any one fact or circumstance stands alone. State versus Color. Based upon the above referenced facts and given the court's consideration of the totality of these circumstances, the court finds that Sergeant Phillips had probable cause to arrest the defendant. 4, implied consent. The defendant argued that Sergeant Phillips did not have adequately and properly read the implied consent card right to the defendants in accordance to OCGA 40-6-392 and 40-5-67.1. The defendant therefore argues that her consent to the state administered blood test was not voluntarily administered. OCGA 40-5-67.1 provides that provides that the implied consent notice shall be read in its entirety, but need not to be read exactly as long as the substance of the notice remains unchanged. The determinative issue is whether the implied consent notice that was given to the driver was substantially accurate so as to permit the driver to make an informed decision about whether to consent to testing. State versus Stroud. The court reviewed the body cam footage for the incident in question and find that Sergeant Phillips substantially complied with the substance and the notice as set forth by OCGA 40-567.1B2. So that part, the judge is allowing. Independent test. The defendant argues that she was not provided with an independent test upon request pursuant to OCGA 40-6-392. In response, Sergeant Phillips testified he did not understand the defendant made a request for the independent test. A person subject to chemical testing by the state may have an independent chemical test performed upon their request. OCGA 40-3-392A3. However, when an additional test is not conducted, evidence from the test performed at the behest of the state shall not be excluded where the failure or inability to obtain additional tests was justified. State versus Henry. 2021. The statute therefore indicate a strong preference for the admissibility of the state administered chemical tests, ID at 636. The question before the court is whether the state failure to obtain additional testing for the defendant was justified. It is the officer's conduct that must be justified in order for the state's test to be admissible. ID under Henry. Whether a clear request was made is determined by examining the word used by the suspect, the context of the conversation between the officer and the suspect regarding chemical testing, and other circumstances relevant to whether or not the suspect expressed a desire for such testing. During the reading of the Georgia implied consent card, the defendant says, "So, could I get a nurse of my choice?" In making this statement, the defendant appeared to repeat and clarify that she could have a nurse of her choice. However, she does not make a request for an independent test either at the time or later at the police station. Moreover, when she said this to Sergeant Phillips, she had not yet agreed to take the state-administered blood test. Later, when the defendant was en route to the police station, she asked several times whether she could blow now. In reviewing this language, it is not clear whether she was asking for a state-administered breath test or an independent test. Based upon the video and testimony provided by Sergeant Phillips, and considering the context of the conversation between Sergeant Phillips and the defendant, the court agrees that it is not clear that the defendant desired an independent test. Based upon the reviews of the video submitted on the record, the court has determined that a reasonable officer would not understand that the defendant was seeking an independent testing. Sergeant Phillips' conduct is justifiable, and the result of the state-administered chemical test shall not be suppressed. Miranda. The defendant argued that any statement she made after the arrest was not admissible because Sergeant Phillips did not read her Miranda rights after she was arrested. In particular, the defendant sought to exclude her statement to Sergeant Phillips that she smoked weed. The necessity, I'm getting tongue-tied. The necessity of administering Miranda warning exists only when the individual interrogated while in custody. Taylor versus State, citing Jenkins versus State. The defendant told Sergeant Phillips that she smoked weed after Sergeant Phillips stated that the defendant, hold on, I got lost. The defendant told Sergeant Phillips that she smoked weed after Sergeant Phillips stated to the defendant that we need to address something. I smell marijuana. Sergeant Phillips testified that he planned to tell the defendant that he was going to search her car. Sergeant Phillips testified that he was not beginning to an interrogation. Counsel for the defendant argues that Sergeant Phillips' statement would elicit a response from a reasonable person. This court agrees with the defendant, so they're gonna suppress that part. The U.S. Supreme Court has defined the interrogation, which must be preceded by Miranda warning, as not only the express questioning of a person in custody or its functional equivalent, but also any words or action on the part of the police other than those normally attendant to arrest and custody that the police shall know are reasonable likely to elicit an incriminating response from the suspect. Rhode Island versus Inns. In this case, telling the defendant that we need to address something changes the tone and context of the conversation between the defendant and Sergeant Phillips. Further, telling the defendant that he smelled an illegal substance is reasonably likely to elicit the defendant an explanation regarding whether she had consumed the illegal substance. Thus, statements made by the defendant after she was arrested will not, you hear me, will not be admissible in this manner. So therefore, the weed smoking that she said she smoked some weed will not be allowed, it will be suppressed, okay? Conclusion. Oh Lord, I don't know why these people call it conclusion. For the foregoing reasons and for good cause shown, it is hereby ordered that the defendant's motion to suppress is granted as to the HGN evaluation evidence and any statement made by the defendant after her arrest and denied all other evidence. So the two things that should be suppressed is the HGN and her statement after her arrest. Okay? So you guys got it? All right? You guys got it? Y'all heard that? So that is the motion, the order that the judge did. So let me also tell you something else. Hold on a second. There's something else that was the motion to suppress, but let's go something. Hold on a second. This website is spinning. It's spinning. And also, her attorney submitted a certificate of review to the courts. Okay. So the hearing on the 13th will be discussing the state's motion to compel. That's what they're going to be discussing. I don't want to. Yeah, I'm not purchasing this. This stuff is too expensive. Look at this. This is the motion to compel. The motion in limine. They want you to pay for every single stuff that you want to read. Look at this. I'm gonna show y'all. Y'all could go purchase this if y'all want to. But this is the motion to compel. Right here. Motion in limine and motion to compel. If you guys want to go purchase it, y'all can. But I'm not purchasing no more stuff from these people. This is highway robbery. It's $1 a page, y'all. $1 a page. Okay. So when I did put in my Rule 22. I did get an email back from the court. They're saying that they're forwarding it to the person that's responsible for that. So I should be hearing something about my Rule 22 sometime today. Okay, so I will be at the court. Even if I don't get approved for Rule 22, I'll still be at the court. I'll be at the court for the hearing. What's the court case? Tiffany Haddish. If you go back to the beginning, you'll be able to see what she's being charged with. She has 7 charges, and every single one of those charges is misdemeanor. Yay! I just got my Rule 22. It was approved, y'all. It says your Rule 22. Miss Parks to Miss Seaman, your Rule 22 request is approved and will be signed by the Judge Thomas on Monday. Please report to Courtroom D at 8 a.m. to set up your equipment so you can discuss logistics so the filming does not interfere with the court business. Also, FYI, the hearing for the defendant Haddish will be conducted via Zoom in Courtroom D. I got my Rule 22 signed. Woo woo, woo woo, woo woo, woo. Tiffany won't be there in person, so she'll be on the camera. Oh crap! Well, so we just got it. Do you see how quick they do stuff in other counties, y'all? You see how quick they do it? They do. I put it in this morning, and they just did it just now. You see that? Okay, we all in it. We in it now, y'all. We're ready for Tiffany's hearing. We will be there. We will be there on Tuesday at 8 a.m. I got to be at the courthouse. I got to get up early in the morning. Lord have mercy. Let me see how long it's going to take me to get down there. Lord have mercy. Jesus. Let's see how long it's going to take me to get there. Hold on. 1 hour and 4 minutes. Lord Jesus. Okay. So I got to get up early. I got to get up at 4:30. Leave the house by 6. Yeah, leave the house at 6 and be there. Because you never know traffic, y'all. So I always try to leave super early just in case. So we will be there. We're in it like Flint, y'all. All right. Our next Rule 22 we're going to put in is for the juror. Remember that juror? We got to put in our Rule 22 for that. We got to put in our Rule 22 for you said she's a mean girl? Mm-mm-mm. You know what? Let me tell you, Judge. Let me tell you, Judge. Yeah, the judge is a DUI judge. He the one. He's the one who launched the DUI drug court and veteran treatment court. So, yeah, she's going to be taught a lesson. That's why he's not letting it go. I did stand up for therapy after my mom passed. Tiffany did not like another funny black girl sharing the stage with her. He did a stand up for therapy. What? What? Do tell. Do tell, AWMS. Tell us more. Ooh, child, we always get some good people up in here. Tell us more. Ooh, child. Let me do my little noise. Let me do my reaction noise. Hold on. I'm learning how to do this, y'all. Let's see. Oh, that's not the noise I want. Do tell us more. Hold on, let's go. All right. Do tell us more. Tell us more. So we're set. We're set for okay. So that is it for today with Tiffany's situation. So I will be going to the courthouse then. All right, guys. Any question, good people? Man, that was the quickest ever. I'm telling you, I be getting some quickies when I go out of the big counties. You know what? No other county give me a hard time because DeKalb County was good to me. I did DeKalb County. I did Gwinnett County is pretty good with me. So Gwinnett, the only two that really gives me a hard, well, Fulton don't give me a hard time. They just take too long to process theirs. Right now, the only one that ever rejected me was that one case, which is Cecil's. That's the only one that rejected me. That's the only one. But everybody else I've gotten approval for. So I've done over hundreds of Rule 22s. Hundreds, y'all. Because we don't even talk about the small cases that I've had. Only one reject. Only one reject out of hundreds. That's not bad, is it? Not bad for a girl like me. Not bad at all, y'all. Any questions, guys? All right, I will check you guys later. All minds are clear. All hearts and minds are clear. Can I leave now? So we already know they're not going to go to trial. They're not going to trial on the 3rd. I guarantee you they're not going to trial. How much you make a bet they're not going to trial on the 10th? Excuse me. How much you make a bet? Anybody want to bet me? Anybody bet me they're not going to trial? Because if they're doing a thing on Zoom, the hearing on Zoom, because you know the other stuff, they got to go to court. They got to be in court. You know what? I'm trying to see a way I could go ahead and live stream it for you guys. On Tuesday. I'm gonna see if I could live stream. If not, I just record it on my camera. We'll see. Since it's gonna be on Zoom, maybe I could live stream it and we could. You said my intro song is fire. Thank you. Thank you. Thank you. I did it. I did it myself. AWMS. Oh, I don't know why I'm coughing this morning. I must have slept under the air conditioner. Golly. I gotta get me some tea this morning because I'm getting this coffees. It's not good to get a summer cold. It's not cool at all. So I'm going to go ahead on and put in all my other Rule 22s so I can be ready for all my cases. We got so many. It's going to be a busy month. We're going to be very busy in August. I got to put in my Rule 22 for Sarah's case. I'm going to put in Rule 22. I'm going to put in there. And just ask the judge. I got to specify what I'll need for that one. I just want to be able to get the stuff from the equipment. Yeah, that's what I want to be able to do. I'm excited, y'all. I feel so excited to be back in my element, to be back in the groove of things. I feel so good. I feel so good. But anyway, can I go now, y'all? Can I go? Can I leave? Is it okay for me to leave now? Y'all done with me? I'm gonna try to go on my other channel and give something because my other channel's been y'all gonna be so tired of me in a couple of weeks. Y'all gonna be so tired of me because I'm gonna be on every day. I'm gonna be on every day. Y'all gonna be like, oh my God, an overdose of Sylvia. Yep. I'll see you guys later. Love y'all. Bye. I'm gonna go on the other channel. See ya. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until till tears roll down like the rain. In this virtual world, you ease all my pains. We're family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night.